Good afternoon, ladies and gentlemen. I'm pleased to welcome you for the afternoon session of our symposium day. We have had very good interactive sessions in the morning, and we are happy that you're able to join us for this second part of the session. This afternoon, we will be looking at Kenya and the Singapore Convention. And just before we get into that, we will do our usual opening, which includes the national anthem and then some housekeeping. So on with the national anthem. O God of all creation, bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace, and liberty. Plenty be found within our borders. Okay, thank you very much. Sorry about that. We encourage you to be able to use the chat facility to be able to input your questions and your comments as we go along. We will have the presentation and then we will be able to have some commentaries and also have some time for question and answer. This afternoon's session is kicked off looking at Kenya and the Singapore Convention. We will be taken through this particular session by Lawrence Muiruri. Lawrence Muiruri is the Registrar at the National Center for International Arbitration. He has been an advocate for more than 20 years and has been practicing arbitration as well as mediation. He's very well versed with what we can refer to as the alternative dispute resolution options that we have. Bwana Lawrence, I welcome you to say hello to the participants, and I would say that you tell us something that we don't know about you, and then you can be able to proceed with your talk. Thank you very much, Bwana Lawrence.
Okay, hopefully you can hear me.
Yes, we can hear you.
Greetings, everyone. It's a pleasure to join you this afternoon. Let me first thank the organizers for giving me the opportunity to speak on this very new subject. And I hope the time we shall spend on it shall be useful for all of us. I must say right at the beginning, for us all, it's still a learning since it's a recently passed convention. But we shall make the best use of the time that we have together. Since I've been asked to say something about myself that perhaps most of you will not know, I'll leave the academics since they have been covered, and career. I'm the husband of one wife and two girls and boys. Yes, that's about what maybe most of you would not have known. Thank you.
Okay, Lawrence, you can go right ahead with your presentation.
Okay, thank you. Once more, it's a privilege, a humbling one, to cover a subject which is still very new to many of us, I included, but of course, since having engaged in this area, there's a lot that we can benefit from each other. So feel free to interact in the question session. If there are things that perhaps you may think I would not have covered, let me know during that session. For purposes of flow on what I'm going to be speaking on, as has been indicated, is the Republic of Kenya, the Singapore Convention on Mediation, what next for commerce, I'll begin with a historical background to this convention as my first point. And given it is new, I'll spend a little bit more time on the historical background. Secondly, I'll look at the potential influence the convention will have on the practice of mediation globally. And then thirdly, I'll look at briefly on what next for Kenya in light of this convention. I know I'd been asked to speak on Kenya's understanding, but admittedly, given that the competent authority is reposed elsewhere, I may not say much about Kenya's understanding, and I'll indicate why that would be the case. And then finally, I'll say something about the Nairobi Center. Just to correct, it's not national, but Nairobi Center for International Arbitration, and ways in which we have been engaging both with the mediators on this forum, Wasiliana, and also as a country with regards to mediation, and hopefully forge new ground for collaboration now that we have this convention. So straight to the subject, I begin with a historical background, and allow me to spend a little bit more time here. I think that's what, since it's not been, it has not come into force, a lot of what we have is a history behind it. It hasn't been tested, and we shall therefore wait for time to see the effectiveness of the convention. The Singapore Convention on Mediation, the larger title being the United Nations Convention on International Settlement Resulting from Mediation, has a history, and allow me to describe it as, for those who were there when we had sibling hand-me-down, where the older sibling would pass on articles, clothing, and the rest, books, to the younger siblings. The Mediation Convention, as we shall see in the history, as it began, was really not about mediation. But in the course of discussions in a body called the UNCITRAL, that's the United Nations Commission on Trade Law, what was the conversation on conciliation turned into a conversation on mediation. So that by last year, when the discussions were concluded and the convention was signed, we now had a convention on mediation. Maybe the jury will be out there whether mediation is a younger sibling or conciliation is the older sibling, but there seems to have been a handing over of the conversation, eventually mediation taking the lead. How did this come about? In about July 2014, at the 64th session of that commission, the government of the US, and so it will not surprise you that the US was one of the first nations to sign the convention last year in Singapore, given that they, in fact, were the ones who moved for this commission to consider an instrument for recognition of settlement agreements resulting from not mediation, but conciliation. And that's in July 2014. The argument behind that was because in the view of that government, parties wanted greater certainty arising out of settlement agreements. If that was done, the conciliation will be attractive because there will be an expedited enforcement mechanism. And then also, they wanted to see an end where settlement agreements were treated in the same way as arbitral awards are. For the longest period, the divide between mediation and arbitration in dispute resolution has been the question of enforcement. Arbitration has had an enforcement mechanism. Mediation has not had an enforcement mechanism. And eventually, the global desire being to promote finality and settlement of cross-border disputes, thereby reducing the chances of parties engaging in protracted litigation over settlement agreements. As you'd expect, there were doubts as to whether this was possible, whether the Convention on Conciliation was going to be agreed amongst the nations. And some of the objections or doubts that had been raised were, some people felt that maybe the New York Convention on Arbitral Awards was sufficient so that parties who are engaged in conciliation, once they agree and arrive at a settlement, they could transit into an arbitration forum where the agreement would then be recorded as an award of that tribunal. There were challenges to that, and of course that was rejected. Others also are feeling that maybe if we formalize settlement agreements arising out of conciliation, eventually it would diminish the value of conciliation itself. But however, through the discussions of this group, eventually the following year, in July 2015, there was a consensus that it was possible that countries can discuss and explore the opportunity of arriving at a convention on conciliation. We still haven't reached the point of mediation. So in July 2015, countries agreed there's possibility of discussing a uniform model to harmonize, unify the law on conciliation. Which brings me then to something that had happened before even 2014. So in the 1980s, this commission had also been considering a model law which could be used by states to enact their own laws back home, domestic laws, on conciliation. And although eventually a model law was developed in 1980, however, this was not adopted. And by around 2002, there was the model law on conciliation, which had something missing in it, that countries were still not able to agree on according enforcement or settlement agreements. So it was left at that, a model law, and countries were left with the discretion to provide for a mechanism for enforcement. And of course, that was not effective, and no wonder, therefore, that it was not implemented by many countries. So it is interesting that the same conversation arises in 2014, but now with a push towards filling that gap of enforcement. So then what changes? We come to the year 2018, and what began in 2014 by the presentation by the US government as a proposal for a convention on conciliation, then finds a proposal for change from conciliation to mediation. And here it was termed as merely an exchange of terms, so that the mover considered the convention now to be titled mediation as opposed to conciliation, to still be covering the very same intent. And perhaps when the time for enforcement of this convention comes, maybe practitioners and those who have an interest in studying the differences between the various alternative dispute resolution mechanisms may want to interrogate what exactly did the discussions arrive at. Well, eventually, they did agree to change the terminology from conciliation now to mediation. And so the path was paved for model law. In fact, at that time, what they were discussing was still a model law, but now not on conciliation, but on mediation. And that's why I said mediation basically snatched the game from conciliation. The support of this change was that these terms are synonymous. However, mediation has more acceptance and usage across the globe. That being the case, once the commission agreed to change now to mediation. We then eventually have a very short period. In fact, it was a wonder. It's not usual for a convention to be agreed within a short period of about, if you take it 2014 to 2018, between 2018 and 2019, when the actual discussions happened, 1 year, and a convention was agreed. That may be an underlying indicator that states were already ready. The situation was ripe for enforcement of settlement agreements, and that maybe will influence one, acceptance of this convention, and eventually also the implementation by various users. So with that history in mind, we can conclude that it appears that the global community is now agreed. There's a large consensus, not just with the large nations, but across the globe, that time is ripe for disputes across borders to be resolved by way of mediation. Secondly, we also have seen that by so doing, the countries have also accepted to elevate settlement agreement arising out of mediation to the level of what was previously accorded to arbitration, arbitral awards. So that rivalry, whether it is perceived or real, that has existed before between arbitration and mediation, may be a thing of the past from now on with this convention. In fact, as one eminent arbitrator called Gary Bourne did mention, they are now no longer enemies. In fact, they have never been enemies, but they are frenemies. They are friends who are enemies at the same time in terms of being competitors for the very same business of resolving disputes, and which is a major step, so that mediation is no longer looked at as a lesser process. Of course, previously people were reluctant to use it because of time spent on a process that was not binding in the end. And so that has already been resolved by this convention. And now to my second point, which is, what is the likely influence of this convention on the global practice of mediation? And right at the onset, I would say this is a major step in the right direction for mediation. Just looking at the number of states that signed up on the date of signing, that's 7th August 2019, 46 states signed up. And when you look at the profile of these states, the major economies that control trade were involved. US, the mover of the commencement of the discussions, China, Korea. That's already an indicator of where the world is moving. As soon as some of these major parties sign up to a convention, it is just a matter of time before the rest of the globe follows in their footsteps. So 2018, the UN Convention, the UN General Assembly adopts the recommendations of the Commission. On 8th May 2019, it is opened up for signature, and 7th August in Singapore, the 46 states signed. To date, as I have checked, 52 states have signed up to this convention. 3 instruments of ratification, which were required for the convention to take to become enforceable, have already been deposited with Singapore, Fiji, and Qatar by 12th March, having placed their instruments of ratification with the Secretary General of the UN. That means within 6 months from that date, the last date was 12th March. So by 12th September 2020, this year, this convention will come into force and parties can start to use it. So what does that then portend for us in terms of the practice globally of mediation? One, the way I see it is that the convention becomes a game changer in many ways. It has resolved some of the challenges that we previously had on the subject of enforcement of settlement agreement. of what I would not go through the articles one by one of the convention. It's a very brief one, 16 articles. What I'll try to tease out is the main points, which I believe will be the main influencers of whether the acceptance and utility of this convention. One of them, the convention does not require that disputing parties have to have had an agreement to mediate. And that's a key point. The parties do not have to have agreed to mediate before the dispute and the process that arrives at a settlement agreement. So which means that regardless of whether parties have a contract before or not, the focus of the convention is on the outcome, which is that there ought to be a settlement agreement arising out of a mediation process. We shall see how it interprets. So Article 2, when you look at it, you see that the basis upon which the process began has now been rendered irrelevant. Whether parties had entered into an agreement to mediate should a dispute arise, that is no longer an issue. Whether the process, in fact, some have suggested, was influenced by the court moving the parties to move to mediation, that is now a thing in the back burner. It does not require the involvement of an institution in the process. Whether or not the process was entered into voluntarily or not is no longer an issue. And also then it means that some have suggested in looking into the convention that a process may have well begun in court, but the parties eventually agree by way of settlement, and that we say we shall test may very well also fall under the auspices of this convention. The other thing that I have noted, which is worthy of mentioning, is that for the settlement agreement to be enforced under this convention, it must arise out of mediation. And I think every mediator in the House should be saying this is a great step in acknowledging the great push that we have been putting to place mediation on the table. So one, it must result from a mediation. And the good thing is that the definition that has been given to mediation is very broad. So the usual challenges that we have of defining whether a process is or is not mediation, they somewhat have been silenced by the convention. Maybe for the benefit of the conversation, Article 2 defines mediation to mean a process. To note here, one, irrespective of the expression used, so whether the parties call it mediation or not, or the basis upon which it is carried out, what I've just mentioned earlier, there don't need to have been a contract submitting disputes to mediation. There actually need not be a contract, even when a dispute arises, to refer a dispute to mediation, so long as parties move in the line of amicable settlement, as the next line says. So irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute. So again, the intention of the parties attempting to reach an amicable settlement of their dispute, and I think this is a key, with the assistance of a third person or persons, and they note there the mediator, lacking the authority to impose a solution upon the parties to the dispute. So there we see some of the characteristics, major characteristics. The parties attempt to reach an amicable settlement of their disputes, and there must be a dispute, with the assistance of a third party or parties, and then that third party lacks authority to impose a solution. And we can pause here and say that third party is unlike an arbitrator who actually does impose a solution by issuing an award. Now, for mediators, you realize the definition provides a very wide scope of the processes that we engage in to be perhaps considered as matters within the purview of this convention. And then the convention requires that that settlement agreement arising out of that process is in writing. And the definition of writing, the settlement agreement broadly encompasses a wide scope of writing. So it says a settlement agreement is in writing if its content is recorded in any form. The requirement that a settlement agreement be in writing is met, here one, by an electronic communication, if the information contained therein is accessible so as to be usable for subsequent reference. And I can stop here and just point out some great gains here. The content is recorded in any form, so there is no form. Issues of form will no longer be matters to be considered to argue against a settlement agreement. If the parties have recorded their agreement in whatever form it appears in this convention, that is a first step. And it has also accepted electronic communication. Many jurisdictions have struggled with the question of when and how to accept electronic communication. Then it also says that electronic communication is accessible so as to be usable for subsequent reference. Now, as I have mentioned, there will be scope and time when the convention is tested to see how courts in various countries will interpret the broadness or narrowness of these definitions. However, as it is now, it appears to be wide enough. Then I think here is where now it starts to define the scope and limit the scope. That dispute must be a commercial dispute. So it is not all disputes, but commercial disputes. Now again, the convention has avoided interpreting the term commercial, and I think fortunately so, so that the term commercial will require interpretation over time. Again, a lot of guidance here will be given by the various courts, which will be called upon to enforce these agreements. So the dispute must be commercial. In addition to that, the dispute must be international. So it's not just commercial, it must be international. And the key change here is that the internationality of it is about the agreement, not the mediation. So however seated, wherever seated, the parties and the mediators is really not the question. The main, that is to do with the mediation itself. The main consideration is where the parties are situated or the places of business are situated. And when you have time, you can look at Article 1, 1A, and 1B. And it is good that they separated this from the mediation process itself. Because for those who are familiar with arbitration, the question of where the arbitration is located is a significant issue. And it has occupied many conversations. It has occupied judicial consideration as to where the arbitration was seated, because that affects the law of the arbitration, not so with this convention. And so, again, we have avoided a potential pitfall just by removing focus on the mediation to the agreement in terms of it being international. Then there are two situations where this convention will not apply. One is where that commercial transaction is by a consumer for personal, family, and household purposes. So it may be international, it may be commercial, but if the purpose for which that transaction was entered was for personal, family, and household purposes, it is not covered by this transaction. I would imagine if I buy a phone for my own consumption, this will not be one of the agreements that would be covered if there was to ever be a dispute by this convention. Again, also, matters of personal law, family, inheritance, and employment law will not be covered by this convention. and therefore any disputes which eventually have a settlement, even through mediation, but they're in these areas, family, inheritance, and employment, will not be covered. You can imagine why. The question of family personal law is varied. You can find even within one country people of diverse or multiple personal law reference, and therefore it was unlikely that there would be harmony or a unified format of determining this, and then also because of the various domestic laws of different countries with regard to personal law, succession, and the others. And then I would add to that, it will also not apply where the agreements are court-concluded agreements, which are enforceable as judgments. So we participate in a litigation in court, we settle as parties, the court adopts that as a judgment of a decision of the court, and it is enforceable as a judgment. That is not covered by this convention. Or those that are enforceable as arbitral awards. So we may settle, and then eventually somewhat appear before an arbitral tribunal, and that tribunal adopts our agreement. That is also not enforceable under the convention. And then all this goes then to the main subject, which was the gap that was being closed, enforcement. So in terms of influence in the practice of mediation globally, what this convention has achieved, it has now recognized mediation. It has given it certainty, and it has also made it legitimate, the outcomes of mediation to be viewed as legitimate. In fact, you would say it has elevated the status of mediated agreements. Previously, a mediated settlement agreement was in some jurisdictions considered as a contract. Now, being a contract, if you want to enforce it, you'd have to go through court, file a case, and be subject to the same laws of contract. And now that has been removed by this convention. It has also, just looking through at the conversations during the time when the commission was looking into it, it has not required that the settlement agreement be monetary. So it appears it could be monetary and non-monetary. For those of you who are mediators, you know, or you have observed that in many cases, there will be instances where monetary and non-monetary issues do filter into an agreement. They're intertwined, and it's not easy to separate them. However, caution must be had here that when parties are maybe eventually entering into settlement agreements, which they hope to enforce in this convention, the latitude of creativity must be guarded, given that sometimes it may pose a risk of enforcement when the matter ends up in the court of enforcement. As I have observed, there is no seat for mediation, and therefore it means you as a mediator seated in Nairobi, another one in Uganda, a party in Ukraine, another one in Philippines, concerning the same transaction, and the parties eventually agree, the subject of where you sat or which law you applied will not be an issue as far as this convention is concerned, unlike arbitration. And then the convention steered away from questions about, you may call it governance, issues of the principles of mediation, issues of confidentiality, independence, and the like. And it appears the convention, if you look at the discussions, they left that to the domestic laws of the countries, which will be the parties who will be called upon to enforce this settlement agreement. As I come to close on what I find to be the game changer with this convention, I will go back again to this issue of the question of the seat. If there's anything that this convention has achieved, that will, with time, prove to be the silver bullet is not requiring there to be a seat of mediation, because what has complicated arbitration, but of course, with necessity, is a question of which law applies. And removing that from the mediation has opened, in my view, the floodgate for parties who want to use alternative methods other than litigation or arbitration to now have access to an international framework for resolution of their disputes. So other minor issues which the convention has resolved and given a degree of latitude to the party states. One is that assuming Kenya today becomes a party to this convention, Kenya will determine the competent authority to enforce settlement agreements. So it may determine that to be the High Court, it may determine that to be the Court of Appeal or the Supreme Court, whichever. But each country has the freedom to designate a competent authority. Now we have room there to learn from what we have learned from arbitration in terms of who is best placed to be the competent authority. Of course, it must be an institution that has the power to effect and enforce its decisions. To a large extent, domestic law has been rendered irrelevant, especially with questions on grounds for enforcement and rejection of enforcement. By narrowing the grounds for rejection of enforcement, that has meant parties will not be running to domestic law to challenge settlement agreements. Now, again, we say it's still very new. We have not known a shortage of ingenuity in litigation, and parties are likely to start testing the courts on that issue. The country also, which is a party to the convention, will prescribe the procedure by which that competent authority will admit and eventually enforce a settlement agreement. The good thing is that you don't have to go through litigation before that competent authority. Once you comply with the procedure required by law, and for your benefit, you may want to look at, Singapore has already gone ahead. By February this year, they enacted their International Mediation Act, which prescribed the process by which you can now enforce, once the convention comes into force, you can enforce a settlement agreement in Singapore. So it's just providing the procedure. For grounds for refusal, those in some respects have some semblance to what we have under the New York Convention. So Article 5 does give a couple of grounds by which you can, the court, the competent authority, can refuse to enforce or to give relief in this settlement agreement. I'll just shortly highlight them. The agreement is not binding and final according to its terms, so it will look into the terms of the agreement. There is some incapacity of the parties. Maybe parties who agreed they did not have authority to enter into an agreement. It might be that the agreement has already been performed, and so there's no need of enforcement elsewhere. Or maybe the agreement is not clear, it's incomprehensible, or granting the relief would be contrary to the terms of the settlement agreement itself. And worthy of note for the mediators here, that a mediator has breached standards applicable to the mediator. And so, again, in terms of contribution, elevating the practice of mediation to professionalism. We will want to know which standards are these. Are they standards of the country where the mediator was hearing this, was facilitating these parties? Is it where the court is being asked to enforce? It is still not clear which standards are these, but there's mentioned there the standards that are applicable to the mediator, if breached, can be one of the grounds of refusal for relief. And then finally, the mediator failed to disclose justifiable cause for impartiality. So again, if there was anything that could interfere with the mediator making a just facilitation of the process, then that could be one of the grounds for refusal. And then, of course, the headache for arbitration, public policy. So again, the court, whichever competent authority that is asked to enforce, can decline to do so on the ground of public policy, or that the dispute is incapable of settlement under the law of that country. So as I wind up to the influence to which this convention will have, I have noted professionalism. Mediators will now be called upon to operate within a global standard. Then it is, in my view, now a boost in promoting mediation. Mediation now has a platform by which it can advocate, it can market itself. Previously, the question a party would always ask you is, how enforceable is it? Why should I engage in time and cost when whatever we agree can still be trashed? That is now in the past. And then it has also then given a platform for practitioners to now invest more, in my view, in this area. And in close, to say that there is a potential cross-pollination of ideas across jurisdictions as practice is developed, as countries adapt this convention. Eventually, as we have seen even with arbitration, what is practiced internationally eventually will cross-pollinate, and there might be harmony in the end, some form of unity in the way in which mediation is practiced across jurisdiction. What is Kenya's understanding? As I said in the beginning, I will not be the competent person to address that question, given that the only way a country communicates its intention is either by signature, ratification, acceptance or accession to the treaty. To my knowledge, so far, that has not been done, and so it is still premature for us to ask what is Kenya's understanding of this convention. And given also that it was not one of the state parties in members of the working group that developed the convention. Let us assume the scenario where we eventually become a party to this convention. If that does happen, maybe one of the things that we may, of course, potentially see is a framework, just in keeping in step with what Singapore has done, maybe a framework for international mediation to allow for this convention in terms of defining the competent authority and the procedure. And then, of course, with the ratification of Treaties Act, there shall be conversation in Parliament in adoption of the convention. Beyond that, the benefits that we have globally will likely also apply to our own domestic environment of mediation. Although it is limited to commercial, eventually one field influences the practice in the other fields to the extent that it is applicable. I know I've spoken much. I hope I was clear. I'm ready to pick any questions that may have arisen as a result of the little that I have shared. Thank you.
Thank you very much, Lawrence. Actually, it is not little, it is quite a bit, giving us a very good overview of the convention and the place that it now places mediation and the opportunity that it actually gives to us as mediators. I will give Amanda an opportunity to give a commentary, and then I'll be able to allow Kimutai has had some 2 questions to be able to give his questions. So Amanda, you can be able to proceed, and then next we will have Kimutai.
Thank you very much, Sarah, and thank you, Mr. Ngugi, for the elaborate and in-depth discussion that you've shared with us. So I think for me, I have a couple of, from what you've shared with us, I just have a couple of questions. Maybe, I don't know if you've mentioned, maybe you can just elaborate further. From my very little knowledge, I know one of the edges that arbitration has long had in terms of dispute resolution over mediation, negotiation, and all the others is that the agreements have been enforceable and they have been binding. So in terms of having this Singapore Convention and it coming into effect, has it been able to create an edge such that arbitration do you see a situation in the future where arbitration may not have such a strong position as compared to mediation, since mediation seems to be coming up quite strongly? And my second possible commentary is from the information you've given us concerning the Singapore Convention. If a situation arises where, for example, there's a transboundary agreement, is it that both countries, maybe between a commercial issue regarding one country in the Western world and Kenya, and one has ratified the Singapore Convention and the other has not? What context does that create in terms of now those the commercial agreements that have come into effect through mediation? I don't know if you're understanding what my question is. Okay, yes, those are my only two concerns or areas that I'd like to get some clarification on. Thank you.
Okay, thank you, Amanda. Lawrence, we can have you address those, and then we will move on to Kimutai.
Okay, thank you, Amanda, for the good questions. True, I agree with you. Indeed, the only divide between arbitration and mediation was enforcement, to a large extent. Many may have different views, but if there was one thing that gave arbitration the lead, was that you could have an award in one country enforced in another country. What this convention has done is that it has elevated a settlement agreement to literally the level of an arbitral award, if I may say so, without some of the challenges that arbitral awards carry with them. So I mentioned something to do with the seat of arbitration. There is no seat of mediation. So that being the case, I think what your first question was, will there be competition between the two? And I think I did allude to a comment made by Karibu, a respected arbitrator. They really were not enemies. It's just that one had a privilege of enforcement. From now on, they will be, if you want to describe them, frenemies, friends with enemies at the end there because of competition. And so the reality of the coexistence of these two is that parties now have a choice. They can either go for arbitration, depending on the considerations that drive them towards arbitration, or they can go for mediation, again, depending on what drives them towards settlement. And I think, admittedly, if you look at the main economies, if you consider US, many of, although they are called a country that is litigious, most of the disputes in the US actually are resolved through settlement. So think of the culture of the main economy of the world. Go to China, which is emerging again as one of the major economies of the world, if not competing there. They are also a country that is culturally more inclined towards mediation. So if we think of the effect this will have later, it might be that either it gives the parties the choice, and so these two will continue to grow together, or depending again on how many countries ratify or accede to this treaty, you might have situations where mediation is more preferable than arbitration, but none of them will lock the other out. I think there will be a place for arbitration because there are certain advantages of having it, and there will be a place for mediation because there's also a place for it under this convention. And then with regards to the question of commercial dispute, especially where states are concerned, this will be a matter that will be maybe approached in two ways. The New York Convention, and of course, another convention we call the ICSID Convention on Investment Disputes. This convention has clearly made in Article 7, it has tried to avoid the conflict between treaties. And so wherever there's a dispute, especially where it involves states, what I foresee is that the situation will be determined on the basis, one, whether the dispute is commercial, and even if it is commercial, whether there is another treaty or law that is applicable to the particular dispute. And therefore, parties will have to, by the time they are moving to have a settlement enforced, to consider some of these other treaties that parties may have entered into before. And of course, the subject of regional agreements, I think that is also covered under Article 12. So if you're dealing with EU, if you're dealing with the EAC as EAC, there might be situations where you may want to think of the implications of the agreements between these regional blocks and the effect on the settlement agreement, especially where it involves a state. Then also, finally, I can say, on the question of reservations under the treaty, you will want also to look at in what whether the state party has reservations filed. There are only two possible reservations. One, that government agencies or government department entering into an agreement, that kind of agreement will not be covered by the convention, or a state can ratify the treaty, but with the reservation that the parties to the agreement must have consented to its application. So again, those are considerations that one will have to have regard to. I hope I've answered, Amanda.
Yes, you have. Thank you.
Thank you. We'll just have Kimutai.
Thank you. Asante sana Bwana Ngugi. I hope you can hear me. I appreciate that you're giving us the benefit of your experience and reading. So I'm going to put the questions. I'm not necessarily thinking that you must have the answer. So I appreciate, it's just thoughts which have cropped up while I'm listening to your presentation. One of them which I really appreciated was the fact that the party who is an independent third party cannot be capable of enforcing. So therefore that removes, like you say, the arbitrator, the justice procedures, etc. I was actually wondering, the definition of the settlement agreement on how it can be done seems to mean that even if you started like a traditional justice system and you ended up reducing it into a settlement agreement, it seems like that can actually be under the Singapore Convention enforced. Obviously, it'll have to have a commercial element, but provided it's a cross-border and it's actually commercial and it's a cross-border, I'm wondering whether it'd be possible to come within the scope of the actual act. I've also asked this in other things. We're starting to do a lot of things on Zoom. If, for example, you record the people agreeing to a settlement contract and you are going to reduce it into writing later, is the actual agreement on video, could that possibly be construed as a recording? The third thing was, if you have two parties of which neither country has actually entered the Singapore Convention, does it restrict you from registering the settlement agreement with the Singapore registry? And the third one, which I think you touched on right towards the end, was the issue about do you have to inform the parties prior to actually commencing the mediation that you are holding it capable of being registered under the Singapore Convention, or can you wait until the time as you're actually creating the settlement agreement? Thank you. I hope that's not too many questions, but those are the things that came to mind. Asante.
Yes, Lawrence, you can proceed to address those.
Okay, thank you very much, Kimutai. And even as you ask the questions, already you can see the scope of creativity and the likelihood that because of the broadness of this convention, parties would stretch the full extent and meaning of the provisions. Yes, I agree with you. The fact that the third party is not empowered to impose a solution is a key definer, and that, of course, removes from the scope of this convention areas like arbitration. It also removes courts. However, as I said, it is possible that an issue may have begun in court, but parties eventually agree on their own, and especially where it is not enforceable as a judgment, it could very well fall under this convention. In terms of the question of whether electronic communication might include even video, that might face a challenge by the definition of settlement agreement itself, because it is required to be in writing. And that itself may pose a challenge that will have to be argued. I know there's that aspect of recorded in any form, and whether eventually translating it into writing will qualify for Article 2.2. Then they've also given electronic communication. I would here perhaps foresee issues of email or similar kind of communication, so long as there's proof that it is accessible for subsequent use. Now, innovative questions there would be, will questions of how someone accessed that communication arise? If it is accessed otherwise than by the proper means, will that be a question to be pursued? Those could be issues that will become potential litigation later. And then there's a question of parties who are not, whose countries are not party to the convention. Of course, just by the law of treaties, parties who are bound will be those parties to whom the convention, the state parties have either ratified, acceded, or accepted this convention. And of course, to the last question, which is tied to this one on the party to the convention, the agreement may be before, during, or they actually may not be, because we have said the basis upon which the settlement was entered into, the process that led to the agreement is not really an issue now. What they are looking up to is the outcome, the settlement agreement itself. So whether people had, the parties had a contract before, whether when the dispute arose, they agreed to go into mediation, even whether or not they actually called it mediation. So by whatever expression, so long as there's a settlement agreement at the end of it, which will conform with Article 4, very well might be enforced under this convention. So it has removed a lot of the challenges that we could potentially have had these issues been dealt with otherwise. So the broad definitions, although can be problematic sometimes, but I've also given the room for a beginning. So Kimutai, I hope I've answered your questions.
Thank you very much, Lawrence. I can see Lily asked a question. Lily was asking if Kenya is to establish a statute ratifying the convention like it did the Arbitration Act, would that make mediation somewhat rigid, like arbitration, yet it is supposed to be ADR? And there was also a question from Gibson Yamato. I think Yamato was asking what we need to do in terms of lobbying so that Kenya can get to the place of ratification of the Singapore Convention. Maybe you can be able to take those as well, kindly. Just not yet. Okay, sorry about that. Go on.
Okay, thank you. Just before I answer Lily and Nyamaso, let me go back to Kimotai's. There's an element that I may have missed, the traditional part of it, but I hope I answered it by mentioning how the process began, what the process may be described as or not described as. At the end of the day, so long as the definition of mediation that the convention gives is evidenced and proof is given that is the case, it may very well be that even traditional methods which comply with this definition could eventually result in an agreement that is enforceable under this convention. We bear in mind the history that I gave, that the intention was to create a harmonized or unified framework. And so they avoided taking the peculiarities of practice that may be unique to particular jurisdictions. And so whether it's called traditional in Kenya, it may not be called traditional in another country. Whether it's called conventional in one country and not conventional in another, they have, it has moderated those differences and left us with a very broad definition of what mediation what mediation is covered under the convention. So you might be the first party to want to try to see whether traditional methods which conform to this definition, eventually the outcome will be accepted. To Lily, the question of whether it will reduce the utility of mediation. The convention, as I mentioned, one has confined its application to particular areas: commercial, international, not personal law, not consumables, and not processes which are concluded in court or in arbitration. By that, it has already defined its area and scope of application, so that even if this law that is being enacted in accordance with the model law, for instance, what Singapore has adopted, is barely to provide a procedure by which this settlement agreement will be enforced. It's not defining the substance. It's dealing with which court or competent authority and how will that court process the enforcement itself. By that, it doesn't in any way affect the domestic practice of mediation. In any case, what it might actually do is enrich it. I talked about cross-pollination, when what is done in the domestic looks to what is done elsewhere, and advancement and growth, evolution may be actually the result. Secondly, by focusing on the agreement as opposed to the mediation process itself, that has also eliminated the fear. In fact, I mentioned one of the doubts earlier was that having a formalizing enforcement of mediation settlement agreements would diminish the utility of mediation. But I think the convention that we now have dealt with that doubt and fear by the way in which they have couched the provision. And then Nyamaso, on the question of lobbying, I think the opportunities are there. All of us concerned, considering the utility of the convention, we of course will be more than ready to each of us individually, of course, and maybe even as lobby institutions, once we consider the utility of this treaty, I mean, it's open for us to make a case for it to be considered.
Okay. Thank you very much. I can see Diana says that this is very informative, and that it is good that the global community has agreed that time is ripe for disputes to be held by mediation, and it is good that now the main issue is not where the disputes are situated. It can be international. I think we will move on to the next section of your presentation, Mr. Ngugi, and I'll request you to just help us understand what the NCIA is, what the mandate is, and how we as mediators can be able to engage with you. So, Karibu sana.
Okay, thank you. Before I do so, thank you very much for the questions, and hopefully we can continue to interact even on this subject of the convention in coming days, and especially once it becomes enforceable. And I think with this conversation, what becomes clear is the effort that we as an institution, you as practitioners have been putting to place mediation on the global platform, give it visibility, give it recognition that it requires legitimacy and certainty, has now borne fruit. As the convention clearly puts it, these settlement agreements will come from various directions. And then one area where these agreements will emerge from is institutions such as the Nairobi Center for International Arbitration. We have had for the last now 5 years our mediation rules, which apply both to domestic and international disputes. But admittedly, I think because of the question that has now been addressed by the convention, the gap of enforcement, parties seem to have been reluctant to take up mediation. So the uptake of mediation has not been as we would have wished it was. It is unlike arbitration. And so whereas we have presently a good case load of arbitration, we have very few cases of mediation in nature, and most of them from the public sector. What does that then present for us? It's an opportunity for the mediators to take advantage of the fact that now they are no longer shouting to be recognized. Recognition has come. We have been saying we have something to contribute, to bring to the justice table. It is time that we now become more and more professional. We become more and more structured, perhaps in the way in which we conduct our mediations. Now, that said, one of the benefits of having an institution that administers dispute resolution processes is that is our core mandate. And we have the benefit of having connectivity both domestically and internationally, so that we can very easily and readily bring practices that are international to cross-pollinate them with what is national or domestic here. By this, therefore, then it is an open invitation to you as a mediator to consider and consider verily the opportunity offered by the center to list on its panel of mediators, both domestic and international, because it is only a matter of time before these agreements start, or rather disputes start arising, and parties preferring mediation. Once September 12th comes, the landscape of mediation will change. So the earlier you invest in it, the old adage of the early bird comes in, and with your visibility on the panel, which becomes visible not just here but across the globe, you can very well be able to anchor your service to the international community. Now, that's not the only thing we do. We also offer training in mediation. We will very shortly be launching our mediation curriculum. So we invite you to be on the lookout for our training, introductory training to mediation, our modular training in mediation, which will be certified, and so becoming an NCIA certified mediator. And this opens opportunities for you, because we'll not only just focus on domestic mediation, but we'll also have a component of international mediation in our training. And of course, we still haven't stopped. We have said arbitration and mediation will be frenemies. So we are also continuing to provide arbitration part of the service. And as mediators, therefore, it's now your opportunities to to work across the sectors, both arbitration and mediation. And the only way we can be of effective use is if you're visible to us, and you can only become visible to us if you are empaneled on the panel of NCIA. Many of you will be aware there is a work towards an ADR policy. I think this makes it easier. The path has been paved for an impetus for that policy to become a reality and influence the way in which we approach mediation and perhaps even other areas of dispute resolution. So as a center, we look forward to you joining us on our panel, you joining us as we push this agenda of mediation, and also taking up opportunities either as trainers or training on mediation with the center. Eventually, now that the international community has moved towards harmony, I know the greater question here is, what about harmony in the domestic sphere? Eventually, part of what will be engendered by this convention is us moving towards harmony, so that certification can be recognized across institutions, practice and experience can be recognized across institutions, so that mediators do not have to move from one institution to the other for certification, but a process of recognition and accreditation can make that easier. I think with that I can say Karibuni NCIA.
Okay. Thank you very much, Lawrence. Probably as we just wait to hear from the others, just a question: what is the NCIA doing in terms of positioning itself to be the go-to place for ADR in not just East Africa but Africa?
Okay, thank you. If you have been following the trend of history with NCIA, we have every 3 years sought to not only place ourselves visible to the domestic field, but also internationally. Just this March, we held our second international, this time ADR, Arbitration and ADR conference in Mombasa, where some of you did attend, and I'm grateful for that. We gave it wide coverage in different media in the country. We have also, because of our collaboration MOUs with other centers across the globe, entered into agreements with a center such as the one in Cairo, an agreement with the Permanent Court of Arbitration in The Hague, the we have a structure called the China-Africa Joint Arbitration Center, which is an initiative of the Chinese and African legal fraternity involving 5 centers. These include Shanghai, Beijing, Shenzhen, Johannesburg, Nairobi, and very soon what we call the OHADA in the French-speaking countries of West Africa, and many more will be joining. So by this, we are opening the inroads for one, Nairobi to be regarded as a dispute resolution hub or destination. We are also making the practitioner and the capacity and capability of Kenya as a jurisdiction known to the outside world, and by bringing these practitioners to Kenya, by involving ourselves in their activities. Of course, there's a lot more for us to do. We have kicked off publications on research that we conduct on the caseload that we presently have. The last figures as we closed last year was about 4 billion Kenya shillings, but that is arbitration. Very likely we shall be moving now to focus also on what will come out of mediation. So in these various ways, we have kept trying to push the agenda of ADR itself, and also placing the visibility of the center on the forefront. The process for development of the draft ADR policy was a participatory, inclusive process whereby we as a center also reached out to groups, especially such as Wasiliana and many other interested groups in mediation and ADR generally, towards driving a common agenda for ADR in the country. I think that has been one thing that all of us agree was needed.
Yes, thank you very much, Lawrence. I can see Kimutai asks what the NCIA has done about the promotion of practice mediation to the public. And Christina also says that she's grateful for the presentation and is happy to note that a curriculum will be out soon as a training curriculum and harmonization of the mediation training. So maybe just to respond to, engagement of the public.
Okay, in terms of engagement of the public, the first platform, other than what we have done in terms of promoting the center's services, the process for development of a draft ADR policy was deliberately inclusive and widely participatory. So we went down to the counties, we involved as wide a scope of interested stakeholders as we could, all to the end that we could place all the players and all these fields on one platform, so that the draft ADR policy proposal covers all the processes, including mediation. We have for a long time have a disjointed approach towards ADR, and we thought the first point of intervention was to bring a harmonized approach. And so with a policy, granted that policy normally informs the process of lawmaking, that was the first point of entry to try and bring all these other initiatives to one table and start talking about ADR, not just the different facets of it or the different sectors, but ADR as one. And once this policy is in place, the next level will be sensitization and capacity building and awareness creation. So that again will spread across the entire spectrum of the country. I'm also aware that the TDRMs also have a process that is ongoing. We have maintained a close touch with them so that eventually what policy will come out will have considered the work that is also being done on TDRMs, and that will eventually, of course, harness the harmony that we are looking for. Is there a question I've missed?
No, I think you have covered everything, though we do have a new question.
Yes.
Where somebody asks, Lawi is asking, what is the process of accreditation by the NCIA?
Okay, so Naomi, thank you for asking. We have a robust website which has clear information on what is required, the steps, the stages, but you could give me your email, share with me your email. I could give this information to you, but for the general information of the participants, we have a rigorous process whereby once you meet the conditions that are set out in the standard, which is available on the website, and you then submit your application to us, and that application is processed based on whether or not you meet the requirements of the standard. Again, here we are saying we are moving towards professionalizing the practice, not formalizing, but professionalizing the practice, so that those who profile themselves as practitioners in mediation can be vouched to be competent and capable to be entrusted with what is essentially a process that aids in resolution of disputes. And then eventually a two-tier process within the institution that eventually ends up with the board of directors either granting the accreditation or declining, sometimes declining with areas of recommendation on what the applicant needs to do, or giving reasons why then they are not able to decline, mainly if one has not met the requirements of the standard. But we could engage further. If you give me your email, I'll be more than happy to give you the details.
Okay, thank you very much for that. I can see Joy Namachi says that she's looking forward to the training on international mediation. So yes, hopefully we'll be getting some more information about that as it comes along. I'll give Nyamato Gibson some time to be able to give a commentary. Nyamato, karibu sana.
Hello.
Okay, yes.
Thank you, Lawrence and Sarah, for moderating and the nice presentation on NCIA. Sorry I was late. I was held up in other activities, which I thought would take lesser time, but now I'm here. I joined the discussion midway in the Singapore Convention, and I don't know. I think I will look for Lawrence for a private and in-depth discussion on that. But basically, I'm happy I was able to get some few things here and there on what is needed to be done, and that unfortunately Kenya, we are not a member, and why we not a member, that is a story for discussion, which we need to push. I think we need to join efforts as WASILIANAHUB and every interested mediator to support Lawrence, because he's government, to be able to have this process realized, because it's very important, and it's very important for Lawrence's organization, and it's important for us as mediators, and it's important for the country, so that once this thing is signed, we can be able now to start having impetus as an ADR center in the region. Remember, I think we had a presentation some few weeks where we were discussing on ways of making Kenya a robust center for mediation and arbitration and everything which the Asians are doing, because the Asians seem to have taken a step ahead of the rest of the world in having these processes done so quickly. For example, that's where Singapore actually is the lead in the aspects of mediation. That's why they were able to be the people to bear the process of coming up with a convention. And that in Kenya, we should also be coming up with something in relation to this, because Kenya is not known to be a country which follows people from behind. We are supposed to be world leaders as the athletes and the rest of the things. So I guess it should be in us that nobody is going to move this process. It's a challenge to us. If we want this thing to take an extra step, we need to take that leap of faith and push things. So far, we've done a nice process, as recognized by Lawrence, that we've been shouting around to be recognized. Now we are recognized. I think for us is really to go the extra step further and have this thing formalized. And now with what I think Lawrence has been able to put across, that there is a process of accreditation, which you will not need to go again to Dubai to be accredited. You will not need to go to Kigali again to be accredited, to be world over. Once that process is formalized, then it should be able, a mediator can be able to, once certified by Lawrence's organization, NCIA, then you can be able to go to and have a matter in Singapore and have a client being sent you by a mediator from the other side who wants assistance from this end. And these are the kind of synergies we're looking at. These are things which we should be able to focus on from here onwards. And again, something important which I think Lawrence's organization is doing and which is very commendable, is coming up with an ADR policy. The ADR policy participated in the making of the same in one of the functions, though I was in that focal. So, but it is a process which gives us credibility as a country, as an origin of mediators, that we have some basic rules which we are playing by. Once that is in place, and then hopefully if Kenya becomes a member of the Singapore Convention, then all would be good. All would be good for mediators. And I think that is a beautiful things are happening in Kenya. We just not able to recognize or realize what is happening. We just need to keep pushing. And then I think sooner or later we will be what we want or what we expect us to be. Thank you, Sarah. I think that's my comment as of now.
Okay. Thank you very much for that. I think we have had some very good discussion, and Lawrence, we really appreciate your input and your insight. I can see there is a few more comments. Jennifer is thanking you. And yes, I can see quite a number of people are very grateful for the insights that you have been able to share going forward. I think we still have quite a lot more to be able to discuss. For example, issues about, we have an Arbitration Act. Why don't we have a Mediation Act? Should we have a Mediation Act? So I think there are still many more things that we need to be able to talk about. But for now, our session is just coming to a close, and I would really like to appreciate each one of us who has been here listening, engaging, asking questions, giving your comments, and we're very grateful for being able to come together and discuss these issues. We will be having a break now at 3:30, and then we will be able to have the next session, which starts at 4 p.m. The 4 p.m. session will be taken by Honorable Wanjala, and he'll be looking at family world mediation, and he will also be able to address some of the issues that concern mediation in the courts. So once again, thank you very much, everybody. We will close once we have the national anthem, and then we can have a break, and then you can get back on just before 4 o'clock for the 4 o'clock session. So the national anthem in closing. E Mungu wetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru Raha tupate na ustawi. So thank you very much, everybody. You're free to leave at your will and be back at just before 4 o'clock for the next session.